Thank you for joining us for this feedback session. We appreciate your time. My name is Jaco Swart. I'm the National Manager of NEASA. So on my left-hand side is Mr. Johan Pieterse. Most of you should be familiar with him. Mr. Pieterse is an industry expert in the plastic sector. He was also the lead negotiator during these negotiations for all the employer parties. And we appreciate him assisting us in this session. So the purpose of this session is to simply provide feedback as to where the current negotiations are in the plastic sector, to provide some context as to the environment that these negotiations are taking place, give some background on the PNF and possible dangers and concerns for the sector, and then to just allow you to ask questions and get answers for clarity on whatever you might require. Just in terms of questions, please use the text box or the chat box to post your questions. We'll answer them at the end. Unless you've got a very urgent question, you can raise your hand and the facilitator will unmute you to ask that question at that stage. But if you can leave them until the end, we'd appreciate it. Thank you. Izan, if you can just get the presentation on the screen. Right, there we go. Thank you. So just a little bit of background as to who NEASA is, for those of you who don't know. NEASA is the National Employees Association of South Africa. We are a general employees organization, which means that we represent employers across all sectors, including metals and the MEIBC and plastics under the scope of the MEIBC. We represent approximately 7,000 employers across all sectors. Our core functions are collective bargaining and industrial relations. We've got approximately 50 qualified attorneys, labor specialists across the country in our various offices, and we are nationally located with offices in all the major centres. We are a firm believer of the free market principles and for fair dispensation for employers. It's our mission in life to protect employers and to get the best possible dispensation for employers. So just a little bit on the history of the creation of the PNE, or the Plastic Negotiation Forum. The Plastic Negotiation Forum is the forum where all issues regarding the plastic sector are negotiated and discussed under the auspices of the broader MEIBC scope. So back in 2013, the PNF was established by virtue of a Manco decision. It was a lot of back and fro regarding that. NUMSA and some of the other trade unions were not in favor of the creation of the PNF because they believe in a one-size-fits-all approach. But it was created by virtue of a Manco decision with the assistance of the Employers' Party and parties and Solidarity at that stage voted for the creation. That decision was challenged by NUMSA and the Labour Court, which stated in the case was that the PNF was not formally created. It wasn't created in terms of the constitution of the Bargaining Council and with a whole lot of issues that they raised. And the Labour Court actually found in favour of NUMSA. That matter was taken on appeal, and the Labour Appeal Court eventually in 2016 confirmed that PNF was properly established and that it is the exclusive negotiating forum for all issues relating to the plastic sector. And since then, all matters relating to plastics has been negotiated in the PNF.
Add a little bit.
Yes, please, John.
Just maybe whilst we're on that specific topic, and good morning to everyone. I've had the privilege of seeing the names, and then good morning to all those that I'm well acquainted with. Actually, there's only one person that I do not know personally. Just to deal with the issues at the bottom there, the PNF properly established. The first question that may come up is what is significant? And this is something that we may have forgotten. And I think it's just appropriate if we spend a little bit of time just dealing with that specific issue. Those of you that's been in the industry for long enough will still recall that post the, now I'm lying, pre the establishment of the PNF, the plastic sector was regulated by, in layman's terms, the metal agreement, if I can use it layman's terms. And thereafter, they had their own dispensation. And from there, we actually started to, if I can evolve in terms of an agreement, get more than one agreement in place, which eventually led to an extended agreement. But what is important about it is the agreement that you were subjected to, that was actually something that was proposed and actually was almost advocated by NUMSA and alike, was one that was related to a sector that we could not, when I say we, and I do apologize, is plastics, that we could not identify with. What you have now is you can directly, as an industry, and this is something that is very significant, and if anybody has got businesses that falls outside of the scope of the PNF, but within the scope of the MEIBC, will know what I'm talking about. You don't have the direct influence in terms of what the outcome of a collective agreement may be. The influence is actually very broad in terms of what it is, because there's so many different employees organizations within the bargaining council that makes it quite difficult for parties to conclude agreements that caters for each and every type of business. However, within the plastics, totally different. You can actually be part of whatever the outcome is, number one, the mandating process, and to set yourself on a course that is good for the industry. When I say good for the industry, it's actually taking your operation requirements into account. And Jaco mentioned the 2013 and process and the challenge by NUMSA 2014. Just to revisit that. And why do I keep on saying it's significant? Go back to 2014. There was a question that was asked to the employers at that stage when the matter was taken on appeal. You can either accept the outcome that you will be bound by an unrelated sector, and or you can decide to take it on appeal. The question there was a financial question. What is the cost if you accept your fate? And it ran into the billions. What is the cost if you take the action when required? Around about 1.2, 1.5 million. Now, this is from a financial point of view, it's a simple question. You go in a specific direction. Here, the same applies. If you want to be part and parcel of what will regulate you, you need an independent and exclusive forum, which you've got. Fortunately for the industry, and that is why participation within the specific structure is of utmost importance. You've got control, and you should not be relinquishing that control. Just something in addition. Thanks, Jaco.
Thank you. Thank you, Johan. All right, let's deal quickly with the negotiations itself and where we are currently. So you should be aware that a list of demands was received from all the trade union parties of the council, and there were a number of cost items in those demands, which included wages and increased shift allowances and increased standby allowances and so on and so forth. The employer party's consolidated demand was simply basically the current PIMCA, with only the wages and the duration to be negotiated. So there were negotiating meetings held on 10 April and then during May on 4 occasions. So basically on 20 May, the employers made a consolidated settlement offer and a conditional offer for a 3-year agreement. And those wage increases of 7% in year 1, 6% on year 2, and 6% in year 3 on the minimums as set out in the PIMCA agreement. All the other cost items were removed or has to be removed. That was the settlement offer, and any remaining cost items, or no cost items, beg your pardon, was moved into process. Those are issues like there's chatter about possible medical insurance or housing assistance or stuff like that. So nothing was agreed at it. It simply said that we will look at it, we will discuss it, and I don't doubt that anything is going to come of that. So what we want to do now is just unpack the real impact of the wage offer in terms of 766 on minimums and what the actual impact is in the workplace. Johan, if you can just take us through the application of it.
Thank you, Jaco. If I may ask everyone, I'm going to focus on column C, column F, and then column I. The same principle that applied in the previous agreement, although it's 7% year 1, 6 year 2, 6 year 3, same concept applies. It will be the base rate, which will be column A, 87. I'm just going to start, and I'm just using the top and the bottom, 87.22. bottom 31.54 multiplied by the 7%, and there's a rand value in C, starting at 611 and ending with, I do apologize, I cannot see the number now, but I think it's 2 rand and 21, if my memory serves me correct. Yeah, sorry, I can see it in the next columns. And you will note that the same number is duplicated in column F and duplicated in column I. Simply meaning that irrespective of the actual wage rate the employee is earning at that specific grade, I'm just going to use the example. We started at the base rate is 87.22. Now I'm just using an example. In E, a person's actual base rate is 102 in your business. You still add 6 rands and 11 cents, which is not a 7%, is a 5.9% increase. Or the person earns 107 rand as artisan, which in any event I know is quite low for artisans, but be this just for the illustrative purposes. Then you say 611, which takes you down to 5.7% if you want to look at what is the actual increase. So what is important is that column C is the number that must be given through to payroll per category. However, you will note, and this is something that is a lot of mistakes in our industry, if you note category B has got an asterisk next to it. But it's important. Category B is supposed to be just called a supervisor, but that supervisor is graded 1 grade above the highest grade he or she supervises. I do understand the industry in terms of how it's structured, and I'm just going to use an example. The majority of our supervisors will be supervising up to grade G. So that individual should then be a grade F category. And that is something that impacts on increases significantly, because what we've done is we looked at, and we will get to it a little bit later, the title supervisor, linked it to B, but we did not consider the add-on that the person must then be considered against whom he or she supervises. And that is something that's important. So it does have a direct impact on your wage bill. And it's not that you're going to reduce the current wage rate of a person that may have been given the wrong grade, for argument's sake, B, and I'm just using 71.24. Your increase will go back down to F, which is 2.81 rand instead of 4.99 rand, because you're going to give an increase linked to where you're supposed to be graded. So there's a couple of things that needs to be taken into account, and the same will now apply if you now, for argument's sake, go to 6% for year 2 and 6% for year 3. You just, the column C will change. Only another thing just important in terms of what you're looking at here. The last 4 years, the base rate, column A, remained exactly the same. It started at 87.22 and it ended on 30 June, or will end at 30 June at 87.22. You will now note that if you go now, for argument's sake, and we just move on to D, column D, the 7%, the 6 rand 11 now moves your base rate from 87.22 to 93.33, or and I'm going to go down to the lowest one from 31.54 to 33.75. Simply meaning that you are not allowed to employ a person below that specific wage rate going forward. And just in terms of to understand how I got to the numbers in column E, quite simple. 36.91 would be you've employed a person on the 1st of July 2021, and you've given the individual the increases as per the collective agreement of 179 per year. That will take it to 36.91. So if I'm speaking to your payroll now, and I'm 100% correct, as you know, we are well familiar with the industry and understand how all these things comes about. Thank you, Jacob.
Thank you, Juan. Maybe just to add on to that, the reason we did not keep the base rate static this time around is simply because at grade H, if we kept it static, we would have been caught up by the national minimum wage. We would have been below it. So we had no option to increase it in order to stay ahead of the national minimum wage at grade H. All right, let's talk quickly about the process. Like I explained, we made an offer to the unions on the 20th of May. and they undertook to take that offer for settlement back to their respective constituencies and report back to us on the 6th of June, which is the next negotiating session. So there are two possible scenarios that could play out. So if the offer is accepted on the 6th of June, the settlement agreement will be signed, I suspect, by all parties, and it will be incorporated into the current PIMCO agreement. That PIMCO agreement will then be presented to council, and the council will process it to be adopted as an industry agreement. And that will be the end of that. The second scenario is that the offer is rejected by the trade unions. That will mean that the parties can declare a dispute, a deadlock, and that the dispute resolution mechanisms of the MEIBC will then kick in, which effectively means that as soon as the dispute has been declared, a meeting must be called within 14 days. And then the ManCo, or currently it will be the SGM, since there are some issues regarding the structures of the council at the moment, but the special general meeting will then meet, and they can decide on a way how to resolve this dispute. They've got four possible choices in terms of the constitution of the bargaining council. They can either appoint a subcommittee, which is normally a smaller committee, to try and resolve the issue and then negotiate in that subcommittee, or we can refer the dispute for conciliation or to arbitration, or alternatively, if we believe there's no possibility of settling the dispute, to simply instruct the General Secretary of the Council to issue a certificate of non-resolution. Now, normally what would happen in all the negotiations I've been involved in is that the first option would be preferred, that a subcommittee will be appointed, and the parties will endeavour to try and resolve the dispute and come to an agreement. So if the dispute is not resolved within 30 days, then the parties may exercise their rights in terms of the LRA, which means they can issue a notice of strike, and they can go on strike in order to try and force the employer parties to concede whatever demands there might be on the table. Of course, the opposite is also true. Employer parties may then lock out the trade unions for as long as they are on strike in an attempt to get them to agree to our proposals and our demands. From my take on the negotiations, I didn't see that there's an appetite for strike. We didn't get that those wins. So I think the agreement will be accepted, but we'll see what will happen the 6th of June and provide feedback after that. Then in terms of extension of the agreement, what normally would happen is that if an agreement is reached within the bargaining council, that agreement is extended to non-parties if there is sufficient support for such an agreement within the parties of the bargaining council. And the council constitution and section 32 of the Labour Relations Act prescribes a process that must be followed and certain votes and thresholds that must be met before the council can request the Minister of Employment and Labour to extend such an agreement to non-parties. However, that being said, there's currently a problem with the certificate of representativity of the MEIBC. There were big issues with the last verification exercise, to such an extent that the registrar now has said that his certificate that he issued is not valid, and he is in the process of applying to the Labour Court to have that certificate set aside, which means that verification will have to be redone once that has been set aside, and then we will have to see where we are in terms of extension and the possibility of it. So in the short term, it's not possible to extend any agreement of the bargaining council at this stage. Maybe just a last comment on that. The fact that the agreement will not be extended does not mean that it's not applicable to the parties who signed it. So all parties who signed that agreement will be bound by it as of the 1st of July this year. Unless it is signed after the 1st of July, there will be no backdating on the agreement. All right. I'd just like to deal with some concerns that we have regarding the PNF. Like I mentioned earlier, the PNF was established by a ManCo simple majority vote. And in terms of how voting works in the council and our decisions are being made, and in terms of the constitution, it can be undone again in the same manner by a simple majority vote. So it's very important for us to preserve the structure. NUMSA will love nothing more than to get the plastic sector back into the metals agreement. They like a one-size-fits-all approach, and they're not in favor at all of a separate dispensation of P&F. They've made that very clear over the years, and that has not changed. So our concern is that pressure from the trade unions may cause the plastic sector to be reintegrated into the main agreement, which will immediately cause your current wage rate at grade H of 31.54 to shoot up to a 63.14 rate under the metals agreement, which is obviously unaffordable for the sector and would be devastating. So from an IASA's point of view, we've got 10 seats on the ManCo out of 20 on the employer side. We will never support a proposal to disband the P&F. And hopefully with the support of other employer parties and one or two trade unions, we'll be able to keep that wolf away from the door. We mentioned earlier that there are some issues that we pushed into process that were on the demands list of the trade unions. Some of those are the grading and entry rates, the shift configurations, the memorandum of agreement between the P&F, or the MEIBC rather, and the Printing Council. And those are rather quite technical issues. So we'd just like Mr. Petersen to just give us some background on that and the difficulty we face with those issues.
First of all, thank you, Jaco. I can get used to Mr. Petersen. Just to echo what Jaco said, is if you referred to earlier in the session, you referred to the LAC judgment, the Labour Appeal Court judgment. Exactly what's at the top of this specific slide has been echoed in that judgment. It can either be undone, your P&F can either be undone by litigation. Now we're way beyond litigation in terms of taking the Labour Appeal Court judgment on review to the Constitutional Court. That's never going to happen. However, the second element that is in the judgment itself, in terms of a different decision taken within the bargaining council, and that's the simple majority principle. Just in terms of those three, and I'm just going to touch on three and just illustrate in terms of how sensitive these things may be going forward. First of all, you may say, yeah, trade unions demanding this and trade unions demanding that. Let's just agree that trade unions will be trade unions and they will do what trade unions do. They will not be considering what's best for you or for the industry. They will be considering and be approaching a matter from a specific angle, and that's to assist employees as far as possible without actually taking into account what is the consequences. Now, that is where employers plays a significant role to say, hang on, this is too far, we can't do X, we can't do Y. Now, why do I refer to grading and entry rate? You all have heard a couple of words in your business. I'm graded incorrectly or too low. The one that is most of the time that you hear is, it is not part of my job description. That forms part of your grading, but there's another one that is actually surfaced at the end of last year. When I say last year, not the bargaining council, July to June, the calendar year, end of last year, where employees are starting to challenge the grading system of the plastic sector, arguing that the function they perform is not listed in any one of the categories A to H at the back. We call it the interim technical schedule. I'm going to use an example, but not a company. An example where a person is, for argument's sake, a welder, metal welder, supposed to be building a cage for product to be transported from A to B. They now argue, I'm working with metal, I'm a welder, it's not part of the plastics industry. Accordingly, that specific small part of the business should now form part of the metal side of the bargaining council. It's technically called the demarcation. I'm not here to discuss demarcations. So there's two elements. Number one is I refer to as chipping away at the agreement in terms of the independence, the exclusivity of that specific agreement. And secondly is enhance wage rates. And that's something that I hold dear in terms of a process, and Jaco addressed it just now. Be very careful when you approach these type of things, because the current job title grading system is our problem. I'm just going to use an example, a different example. Grade G, we all know as an operator, but you can get three different operators. One person that operates only one machine, and that's the only machine he or she can operate, and only on instruction. The second one can operate all your machines only on the request or or instruction. And the last one operates all your machines without and actually assist you whenever there is an issue with the machine, fixing the situation, unblocking the bottleneck, and we move forward. Now, all three of them are different types of employees in the same business, but they're paid at rate G. There's no recognition. It may sound like a trade union official. No recognition for that individual that's got the initiative to assist the business without being asked. And there's also now recognition for the person that needs to be asked to perform the function he or she was employed for. There should be a scientific method to say, what is the impact the individual has on my business's bottom line before we start grading. And that's why the scientific models and more the broad banding systems will be good for the industry. My personal opinion is that the employer should embrace this opportunity and correct anomalies without stepping out of the plastic sector itself and be guided by a different unrelated industry. I can tell you now what the trade union's position will be is just to almost duplicate the grading systems in terms of job grading systems from other agreements. For argument's sake, I use my welder example to incorporate it and start regulating it by introducing new rates for new positions, which was never previously there. That is something that I do caution against. You need to have a clear strategy and a firm understanding of the operational requirements and the operations itself before you actually engage in these type of matters. So this may sound very simple and straightforward. This has got to do with hidden cost, because the entry rate is, what it will do is, if I just use an example again, a person called a forklift driver can be now compared to any industry with a forklift driver. And obviously they're not going to come with the lowest level. They're going to come with the highest. And that's where we need to be careful. The second one is shift configuration. No difference between number one and number two, grading and shift. It's all about money. Most of you will understand when I start talking about the difference between a 3-shift and a 3-team system. Now, a 3-shift system, it's simple, 8 hours per day, morning, afternoon, night. You've got an afternoon shift allowance, you've got a night shift allowance, that's what you've got. And you get to maximum 40, and thereafter you work overtime. However, that presents an obstacle, because after your first 12 hours overtime on this weekend, you ran out of your 10 hours allowed, so you will be operating unlawfully. That's why people migrated to the 3-team system that requires a 2-shift, but a 3-team approach, simply meaning there will be always one team resting. That's what we will be facing. However, that requires a specific rotation. If a person are not exposed to your third night shift, consecutive night shift, he or she does not qualify for a night shift allowance. That's what we're talking about. Is we need to change that so people can qualify artificially for additional payments. I'm not saying people should not be remunerated for what they but they are providing for from a time point of view. But if you consider these type of issues in terms of shift configuration, you need to be alert to what is contained in the Code of Good Practice for working time arrangements. It's in the Act. It says that you're not supposed to be exposed to night shift. If you are exposed to night shift, limited amount of night shifts, etc., etc., everything is taken care of there. And if you consider the shift patterns in terms of compressed working weeks, the 3-team or the 4-team systems are actually designed 100% in line with what is required by our legislation. So it's, again, if you do not understand shift work, if you do not understand the processes, sit with the, unfortunately, with the situation that it may sound as if it's insignificant, but if I ask any person now, increase your wage bill now with 15% night shift immediately, so give and take 7.5% on your wage bill immediately, over and above the 7% in terms of the rand value that we're talking about, all of a sudden you become uncompetitive. Those type of issues needs to be carefully managed going forward. And then finally, if you don't mind, Jaco, this is an interesting matter, and it's not going to affect everyone. The Statute Council, that's the memorandum of understanding, is between the Statute Council and the Bargaining Council, but is specifically for flexible packaging. Now, what that is, how that came about is actually quite an interesting history. The history behind that is in 2001, the chemical industry started with the process that they wanted to establish a bargaining council for the chemical industry. MEIBC was concerned and they took the opportunity and expanded on their own scope of registration without taking into account the Statute Council's got the scope of registration for the plastics already. And I'm referring specifically to the packaging, the flexible packaging. Fast forward is the registrar published both scopes, and now since then there was an overlap. Some of you that's been in the industry for quite some time will still recall, in 2003 there was a collective agreement concluded with a phase-in, 10-year phase-in agreement for plastic sector, because that was when the scope expanded, and now they've actually now roped in more plastics companies into the bargaining council. There was a labor court challenge against it by the plastic industry, and in 2006 it was undone. Just in terms of why is it important? Remember, from there, we sit with the scenario that there's two councils, one a statute council and the other one a bargaining council with the same scope. And in 2011, again, fast forward, you will recall that PCA withdrew from the bargaining council due to, if I can use the word, it was in protest against a decision taken by the council or the parties not to acknowledge the collective agreement to process the dispensation for the plastic sector, specifically NUMSA. At that stage, there was a decision, and that decision, I think, is the one that's haunting the trade unions at present, to sign an agreement with the Statutory Council, to say whatever belongs to you and whoever is registered with you remains there, and that you cannot now migrate between the two. And so, but they've done, technically, they prohibited transition between the two councils, and secondly, protecting their territory, if I can use the term territory. This is what they're trying to undo, and that's going to have a significant impact. If you undo the memorandum, which I don't know how you're going to undo the memorandum, because it's an agreement between parties, so you need the other party to agree to undo it. I'm not sure how that's going to be done, but you can bet your last dollar they're going to spend a lot of time trying to undo that. So it's a couple of things that I just wanted to highlight. That I'm not saying run for the hills and I'm now the bearer of bad news. No, there is a lot of opportunities, and forgive me for using the word a bit broad, that employers must exploit in these type of process, but also not be led by the nose that there is nothing that can happen if we take the wrong decisions.
Yeah.
Thank you, Jaco.
Thank you, Johan. I think it's clear that there's significant danger in these issues if they're not handled correctly. They are difficult concepts, they are technical concepts. And in our view, you cannot deal with these issues if you're not an expert in the sector. And to that end, we have engaged Johan as a consultant for us beyond the negotiations to assist us in these issues and negotiating these issues. But as far as we're concerned, he's the leading industry expert for plastics, and we will be utilizing his services. Plastic sector is very important to us, and the autonomy of the plastic sector is very important to us. We cannot allow the trade unions to align the plastic sector with the metals agreement, which they are aiming for. That will simply be the end of the sector. Izan, maybe before we do the last slide, are there any questions that's been posted? Doesn't seem to be. Right. Then just a last slide, just the services NEASA offer. We offer comprehensive industrial relations services, so all your plant level issues, hearings, retrenchments, all that we deal with, all your CCMA disputes, bargaining council disputes, arbitrations, conciliations, up to the labor court, we all do in-house. We do collective bargaining. as you well know. And we have got a range of additional services in terms of employment equity and BEE and POPI and UIF and COIDA and so forth. So we've got a comprehensive range of labour law services. We also provide training on a number of issues, on IR issues mainly, and on main agreements. And we will also be providing comprehensive training on the plastics agreement once it has been signed. So you can look out for those invitations if you are interested in that. We have got a number of rates of packages to suit the needs of employers. We've got a package that's our lowest entry level package, we simply only do collective bargaining. 60 Rand a month if you're interested in that. And if you want additional IR services, you pay as you go. And then we've got a range of other packages up to our platinum package, which is obviously a bit more expensive, but that's all inclusive. All your IR services are included in those packages. So if you're interested, please, you can mail Rona at NIASA. It's an email address at the bottom, or you can email info@niasa, or simply visit our website at www.niasa.co.za. Thank you for your time and participation, ladies and gentlemen. It's the end of our presentation. Thank you so much. Goodbye.
Thank you very much.